Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 7 on behalf of my colleague Pichano, Your Lordship.
Yes.
Kindly let the matter be listed after 3 weeks, Your Lordship. She's here to file her affidavit.
Learned counsel for the petitioner, Ms. Such and Such present. Learned Government Advocate Ms. A. Ayemi makes a mention on behalf of Ms. Pichano Kitan, Learned Government Advocate, to list the matter after 3 weeks as the affidavit in opposition is yet to be filed. So, list after 3 weeks.
Much obliged.
May I please, Your Lordship? I beg to mention item number 9. Lordship, here I am yet to receive instruction, so kindly grant me 3 weeks of time to file my affidavit.
Learned Government Advocate Chungli Songtam submits that he is yet to get instructions in this matter and prays for 3 weeks' time to receive instructions. So, Learned Counsel for the petitioner, Mr. Simons, is present and has no objections. List after 3 weeks. Yes.
Lordship, similar prayer item number 8.
Item 8.
3 weeks, Lordship.
Is similar order. Petitioner's name will be different. Petitioner's counsel. Yes.
Hello.
Lordship, I may be allowed to make a mention for admission item 1. I need to file reply in this, for which I have filed an RTI application. I am awaiting the reply. If it can kindly be listed after 4 weeks.
You want to file a reply to the counter affidavit?
Yes, my lord, my lord.
Learned Counsel, Mr. Santiano for the petitioner, submits that he would like to file a reply to the affidavit in opposition filed by the state respondents and therefore prays for 3 weeks.
4 weeks, my lord.
4 weeks time to file the same. Prayers the Lord, list after 4 weeks.
Deeply obliged, my lord. Lordship, I may also be permitted to move an unlisted anticipatory bail. There is urgency. It is a transit anticipatory bail.
See, the rule is that you have to move it before the senior court.
My lord.
Court number 1. Then after that, if he allows, and otherwise he may refer it to this court.
My lord.
Okay,
my lord,
you make
my
a
lord.
mention there.
My lord, my lord. Deeply obliged.
Please, Lordship. Lordship, I beg to mention item number 5. Lordship, on a consensus prayer, we have taken the consent from the opposite party. If this matter can come up on 2nd of March, Lordship.
Learned Counsel, Mr. Medovero for the appellants who prays for listing the matter on
2nd of March.
2nd of March and submits that the consent of the opposite party has been obtained. So, accordingly, list on 2nd March.
Much obliged, Your Lordship.
May I please, Lordship?
Yes.
I beg to mention item 10.
Item 10.
Yes, Lordship. Here I am appearing on behalf of Arun Long.
Okay.
Lordship, service report upon response to is still awaited, Lordship.
R2.
Yes, Lordship.
Okay. Learned Counsel, Ms. Such appearing on behalf of Arun Long, submits that the service report on respondent number 2 is still awaited. Learned PP, Mr. V. Jimomi is present. So please the matter after 3 weeks awaiting service report on respondent number 2. Yes.
Much obliged.
May it please your Lordship, I beg to mention item number 11 on behalf of my senior for the appellants with consent from the other side if the matter be refixed on 3rd March.
You are mentioning on behalf of
Appellant.
appellant.
Yes.
Okay, Learned Counsel, Ms. Such and Such mentioning on behalf of the leading counsel, the conducting counsel submits that the conducting counsel has difficulties today and prays for listing the matter when? 3rd March. 3rd, matter on 3rd March. So it is stated that the consent of the opposite party has also been obtained. So list on 3-3. Yes.
For motion from the supplementary cost list, item number 12.
May it please your lordship. Lordship, in this bail application, the accused is seeking his right to statutory and indefensible right of default bail. He was initially arrested on 12/6/2025, your lordship, and thereafter remanded on the 13th/6/2025. And Thereafter, Lordship, he was also, his bail application was rejected by the special court. And in the meantime, he was also put under preventive detention under PIT and the NDPS. That detention order was also quashed and set aside on 30/1/2026. Your Lordship, the statute period for completion of investigation under the NDPS Act is 180 days, Your Lordship. And in the case of this accused, that 180 days completed on the 9th of December 2025.
Till date, charge sheet not filed.
No, Your Lordship.
Okay, let's see, we'll call for the records once.
Yes, Your Lordship.
Yes, at least the order sheets need to be produced.
Yes.
The instant application under section 483 of the BNSS, read with section 187 BNSS, has been filed by the petitioner, seeking bail on behalf of the accused, Mr. Mukesh Kumar Yadav.
On behalf of Dhruv Singh, the accused is Mr. Dhruv Singh.
Oh, accused is Dhruv Singh. Okay. By the petitioner, Mr. Shri Mukesh Kumar Yadav, on behalf of the accused, Shri Dhruv Singh, D-U-R-G, Dhruv Singh, who was arrested in connection with narcotic PS case Kohima, number 6 of 2025 under section 21C and 27A NDPS Act, read with section 61 BNS. On, when was he arrested?
12/6/2025.
On 12/6/2025. Stop. Heard learned counsel for the petitioner, Mr. Pokim Yadan, who submits that the statutory period of investigation in respect of the offence under section 21C of the NTPS Act is 180 days, and the same has since expired on 9/12/2025. Stop. The petitioner, the accused had moved a bail application before the learned special judge NTPS on the ground that the accused had acquired an indefeasible right to bail, as the charge sheet had not been filed even after the expiry of the investigation period. Stop. However, by order dated 11/2/2026, the same was rejected. Being aggrieved, the petitioner has come before this court with a fresh bail application. So, the learned public prosecutor V. Zimomi has accepted notice on behalf of the respondent state, and therefore no formal notice is called for. List after 2 weeks. Okay.
A short date, Your Lordship. Why? Because
This
it's in Kohima.
This is from Kohima, no?
Yes.
List after 10 days. Or we can give a fixed date. Today is 19th, today is 20, no? So, 2, 3, 4, 5, 7.
Lordship, if I'm
5th March.
all right.
Yes, list on 5th March 2026. The registry is directed to call for the scanned copy of the trial court records.
I'm obliged.
From the court of Special Judge NTPS Kohima.
I'm obliged, Your Lordship.
For motion, item number 13.
No, please, Lordship. Lordship, this is a revision petition under section 438 and 442 of the BNSS against the impeachment judgment in order dated 25/4/2025, Malak. Passed in criminal appeal number 1 into 4 by the Learned Principal District and Session Judgment. Lordship, before going to the facts, my lord, if your lordship may kindly peruse the annexure 8, which is in page number 115, which is
Page
115.
150.
Yes. The 11th portion is in page number 116.
Oh, okay, okay. So now you have assailed both the
Yes,
judgments.
yes, my lord. Yes, we have made necessary corrections, my lord. Page number 14, my lord, the interpretive portion. Page number 14, para number 3, my lord.
Okay.
At this stage.
The present application under section 438/442 of the BNSS has been filed by the petitioner against, has been filed by the appellant against the impugned judgment and order dated 25/4/2025, passed in criminal appeal number 1 of 2024 by the by the district and session judge Mokokchung. And also the where is that in your cause title, and also the judgment and order dated 25 no. In your cause title again you have missed out. Just see your cause title. In the matter of such and such, then in the matter of criminal appeal such and such. But you have not included the CGM's order. You have to amend the cause title again.
My lord.
Okay, you just say, and also in your prayer you have corrected, but in your cause title you have not corrected. And also the judgment and order dated 9/4/2024, passed by the learned Chief Judicial Magistrate Mokokchung, Nagaland, in what is the case? In GR. In GR number, is it GR number 105?
Yes, 07, my lord.
In GR number,
07 of 2021.
where is that? Where can we find that? Where is the judgment of the CGM?
Page number 77, my lord. 77.
In GR 105 of 2021. Stop. A perusal of heard learned counsel for the petitioner, Mr. Medovero, for the appellant, sorry, stop. A perusal of the petition shows that the cause title is defective, as the petitioner, as the appellant has not mentioned the judgment and order and the case number of the GR number 105 of 2021 relating to the Court of Chief Judicial Magistrate Mokokchung, Nagaland. The petitioner, the appellant, is allowed to take steps to amend the cause title and file an IA for the same within 1 week.
Within 1 week, my lord.
Within 1 week.
Much obliged, your lordship.
For motion, item numbers 14 and 15.
May I bless your lordship? Your lordship, IA has been filed for implement of the person incumbent as respondent number 7, as the 10 respondent number 4, who was holding the post, has been transferred.
Lord Learned Counsel for the petitioner, Ms. Such and such. So, the instant application has been filed, praying for implement of Sri Zaran Thung Izum IS as respondent number 7 in the civil original petition contempt, original contempt petition number 5 of 2024. Stop. Para. The learned counsel for the petitioner submits that the respondent number 4, who was the then principal secretary to the government of Nagaland PHE department, has since been transferred out during the pendency of the COP Civil 5 of 2024. Stop. And thereafter, the Sri Zaranthong Izung IS has taken charge of the said department. Accordingly, it has become necessary to implead Sri Zaranthong Izung IS as respondent number 7 in the civil original contempt petition number 5 of 2024. Stop. Para. The court has considered the prayer of the petitioner and the same is allowed. Stop. The petitioner shall file the amended cause title showing Sri Zaranthong Izung as respondent number 7 in the COP Civil number 5 of 2024 within 1 week from today, and thereafter take steps for notice on the newly impleted respondent within 3 working days. Then in the main COP, you say, in view of the order passed in IA 20 of 2026, list the matter after 3 weeks. And the IA is disposed.
Lordship.
For admission, item number 2.
Minutes. But this is a matter in which I'm invoking the extraordinary jurisdiction of Milets, both under the Constitution, Article 227, as well as under the statute, Section 528 BNSS. Just to refresh the memory of the court, I will request Milets to kindly refer to the first order of 24th February 2025, passed by my lords only. That is a very succinct summary of what is the controversy and why I am seeking the intervention of this honorable court. 24th of February, my lords have got it?
Okay, 1 minute.
My lords. Daily order minutes of 24th February 2025.
I just want to see if the notices are complete and.
Yes, my lord, pleadings are complete, everything. In fact, in last hearing, the court has directed the state government to come with action taken on the basis of report of the learned Lokayukt.
And who's appearing for Lokayukta?
They have chosen not to appear. Service is complete. The state is appearing. Well, actually, I will explain why they are not appearing in the course of arguments. But right now, Millet, service is complete and it's ready for admission hearing. So, my lords can dispose it today if my lords are otherwise satisfied.
As to whether the government has taken any decision on the report submitted by the Uppaluka.
Yeah, that decision has been taken, Millets, and we have obtained the copies, certified copies also, Millets. So there was a recommendation to constitute a committee to supervise such expenses incurred by the government or state in future. They have constituted a committee. So, Millet, nothing with my cause of action that subsists.
So let's see what we read.
Millet's 24th, Millet's can kindly come to order of 24th, Millet. That my lords have itself summoned. So that will.
The daily orders.
Daily orders, Millet, the order of the court.
Okay.
24th of February, that is the first order.
2025.
It's 24th written in my copy. It is 24th of February 2025 minutes.
24 to.
We have got extra copy minutes.
It's okay.
Please.
Yes.
Millets, if my lord can read the second para, it is the case of the petitioner that he was director, LR&S, Government of Nagaland, from 3rd of June 2014, it is very material, Millets, to 30th of June 2023. The erstwhile Vigilance Commission in the year 2015, by an office note dated so-and-so, 2015, had initiated a criminal proceeding against the petitioner without registration of any FIR, as laid down under Section 154 and 156 CRPC, as much as office note at annexure A1 to the present criminal petition is a mere office note and no cognizable offence of any kind has been reflected therein. It is the further case of the petitioner that the report of the CAG, basing on which the investigation was initiated, is a mere report and tentative in nature, which is not final, and it is for the government department concerned to take steps on the same as advised. The petitioner also submits that he has since retired on 30th of June 2023, but till date no disciplinary proceeding has also been initiated against him basing on these facts. The petitioner therefore prays that the proceedings before the learned Lokayuk Nagaland, being case number so-and-so, may be quashed and set aside. So, Millets, these are some of the grounds to which now there are additional grounds, and for which my lords have directed to file additional affidavit. I have filed and which they have not contested. Now, what is the controversy, Millets, if I can explain in 2 minutes?
2014 I'm just wondering whether I can take up this matter.
Is there any conflict, Mills?
Because my husband was in the Vigilance Commission at this time.
Well, that does not make
At
any
this
difference,
relevant
Millet.
time.
Because that is a separate, he might be working separately.
No, he was the head of the department.
But Millet, he was not the Vigilance Commissioner at that point, Millets, when this case was registered. Is it so? I don't know, ma'am.
He was the IGP.
At what time, Millets? That will be material.
During this 2015 to...
Millet, this is the crucial date is, in fact, Millets, that I leave it, of course, to my lords. My lords can take the final decision. But
Let me just see. Show me the impugned order first.
Yes, Millets. Yes, Millets. Millets can come to page 27 of my petition, Millets. This is the office note which my lords have just referred in the order.
Yes.
And my lord can see date is 20th of April 2015. That is a crucial date.
20th of April 2015.
So, Millets.
Okay.
But Millets, I'm perfectly comfortable with my lords. I have absolutely no grievance. My lords, my submission can be recorded.
Okay, sure.
So, my lords can, if the state is having any objection, they can say. But I have no objection at all, my lords. My lords have been very fair and very judicious, so I have all respect for my lords.
Yes.
My lords, this is the office note, my lords. An investigation has been started. My lords, investigation can be started by various agencies under the statutory powers, and one such agency is the police, which takes up investigation for. Now, police can take up investigation suo motu, as well as in compliance of the directions issued by the learned magistrate, which can be either to register a case and investigate, or investigate an existing case where the process has been deferred by the learned magistrate. Milord, in this case, to take up the police to investigation suo motu, that is on its own, without the order of the learned magistrate, the CRPC provides provision under section 154 subsection 1, which says that when an information is received by the officer in charge of a police station, then it will be entered into the register of the police station, and under section 156(1), investigation will be taken up without any orders from the learned magistrate or awaiting from orders anyway. This is the power of the police officer, that is the officer in charge of the police station. Now, Millets, here is a catch. Both police station and officer in charge of a police station are specifically defined and provided in the CRPC and now BNSS. So therefore, Millard, every police post is not a police station. Just because there are 5 or 6 policemen posted in this premises, they don't become a police station. That the state government has to notify that this particular body of police officials will be police station. And ditto, Millets, the officer in charge of a police station is also provided and defined in CRPC. Subsection 2, clause P and clause O.
No, at that point of time, It
Yes,
was
Millets.
declared by notification,
So,
vigilance.
so I'm coming,
station.
Millets, I'm
Yes.
coming. So, Millets, in this case, let us say the state government had declared the vigilance establishment to be a police station. So, Millet, the first requirement is over, that vigilance officials or vigilance post is declared to be police station, so they can exercise the jurisdiction under section 154(1) or 156(1). Bow down, Millets, I agree. Then, Millets, 154(1) comes into the picture. So vigilance police station has to first show that they have received the information, because informant's name has to be recorded, FIR copy has to be provided, entered into the register, and then proceed. That is called FIR. There is nothing called FIR as such. It's a popular acronym, but recording of information is to be, receipt of information is to be recorded with all particulars. Almost every state has prescribed a format for registering the case or registering the FIR. Nagaland has also provided a format, Millets. So, Millet, where is that? That is my grievance. That is my cause of action. That the state has not disclosed. FIR can be registered in two ways, Millets. One is 154(1), where they have to disclose that some person has given them information. He is the informant or victim or complainant, something like that. His name, address will be recorded, time, place, etc. will be recorded. What he says will be recorded verbatim. And thereafter, further action will be taken. Then, Millets, FIR can be registered under section 157 also, where police officer may receive information in confidence from some source. So their state becomes the complainant. The source is not disclosed. So there are two kinds in which an FIR can be initiated. But Millets, both the cases, FIR has to be registered. That is my valuable right, because FIR gives me knowledge that who is the complainant against me, what is his complaint, what he is saying, from where he is receiving the information, if he is not the victim himself or herself. And Millets, I have a right to seek remedies. If the FIR is registered, FIR is liable for intervention by the superior courts. So, Millet, if there is no FIR, my fundamental right of seeking judicial review of an arbitrary action is taken away. That's why, Millets, on this ground, intervention by this honorable court is necessary, because the vigilance police station has proceeded through an office note, which is an internal document, Millets. FIR is a public document, Millet. Now, Supreme Court has directed all FIRs are put in public domain, except some which are slightly sensitive in nature. So, Millets, this FIR, being a public document, cannot be denied to me, because that takes away my right, my fundamental right to seek remedies. If I am aggrieved, I can demonstrate to the superior courts, including this honorable court, that FIR is not sustainable, not maintainable, could not have been registered, could not have been acted upon, so many things. So once my fundamental right has been infringed by the state,
You have filed this in the form of a 482 petition.
Mills?
Is it a 482 petition? 482 CRPC petition?
It is 227 and 528 BNSS minutes. I'm invoking the jurisdiction of this honorable court under Article 227, because ultimately all criminal investigation are the domain of the learned magistrate, which is a subordinate court. So therefore 227 will lie, and thereafter I'm invoking my preserve jurisdiction of this honorable court under 528, because there is a arbitrariness in the state action, and action is not sustainable in the eyes of law.
And what is this IA for?
IA was for a stay, Millets, but that has already been, I was protected, a stay was not granted, but I was protected against any coercive action.
Okay.
So, Millets, IA stands, disposed.
Yes. Okay, then?
Now, Millets, this office note, the first thing is, Millets, that internal office note, which may be for the internal communication between the officers. This office note, Millets, is not a FIR. And without FIR, the jurisdiction under section 156(1) cannot be assumed or triggered. because 156 is contingent upon compliance of 154. Once there is no 154 CRPC, which is now 173 of the BNSS minutes, then 156 or 175 now of the BNSS cannot be put into action. So that is my first. Second minutes, it's a very serious minutes, in fact, very serious minutes. I was shocked when I was shown this by my associates. Millet, what is the date of this internal note? 20th of April 2025.
2015.
15 minutes. Millets, my additional affidavit.
What is the status of the case now?
I don't know, Millets. I am protected by this honorable
What
court.
is the status?
Lokayukta is totally confused.
Lokayukta has disposed of the matter.
Disposed
Of the matter.
My lord,
Now-
disposed not the criminal case. That order is very confusing. It leads to nowhere. Any busybody, any public spirited person can file a PIL. Criminal case cannot be closed by an administrative recommendation, Millets, period. Once the jurisdiction of the court, that is the magistrate, London magistrate, is triggered, whether rightly or wrongly, it has to be concluded either by the London magistrate, either by closing or framing the charge, holding the trial, or by a superior court like my lords, by interfering depending on the facts. My lord, Lokayukt has said, yes, there is irregularity, there is embezzlement, but officers have retired. Some of them are in.
There is a very peculiar situation in the Lokayukta.
Yes, my lord, that's what I'm saying. Lokayukt has acted in a.
Because they don't have criminal powers under CRPC anymore.
Yes, my lord, that is the problem. They could not.
So they cannot charge sheet also, they cannot file a close
That is
FIR
lacuna
also.
of law. That's why, my lords, every Lokayuk, it's slightly, my lords can observe rather and ask the state government to look into it. Every Lokayuk in bigger estates is also attached with a police station. That is called Lokayuk police.
Your case is as good as closed. Nothing
No,
will
my lords.
happen to you.
My lords, no, my lords, there is a risk.
No,
Yes.
nothing will happen to you.
My lord, in that case, my lord can record it. That is what I am seeking, my lords. Just for my satisfaction. I am an old man. I am a retired man suffering with anxiety and all kinds. Court with no prejudice will cause to the state if my lord says that let this proceeding be given a quietus. In whatever manner. I bow down, my lords. Ultimately, my lords, Lokayuk, sorry, my lords. My lord, Lokayuk cannot close a criminal case. They have to refer it to the police station, their police station, who in turn has to file a report to the London magistrate, recommending either closure or prosecution.
So there is no police station now.
So, Millard, that is a lacuna. So, I'm hanging, Millard. That is what I'm saying. But I'm seeking quashing on merits, not because there is no police station.
Yes, of course.
That ground I'm not taking, Millard, because that gives me no right.
Okay, one ground is that regarding the FIR.
No FIR, Millard. And second, Millard, I'm coming. I will request my lords to kindly come to my additional affidavit, which I filed in compliance of directions of this honorable court. It's a very small.
When is it filed?
Lotha, you are a stupid person. Very date.
Date?
File application without date. It is filed in September 2025 minutes. 10th, oath is on 10th of September 2000. Always put date in the index. No, it is not there. And it is drawn by you. Okay. So it is 10th of September 2025 minutes. It's a very small, few pages only.
Yes.
In fact, why the court directed me to file this affidavit, I will request Millets to kindly come to page 4 of my affidavit, Millets.
Yes.
Millets have got it. This is a copy of a letter. I obtained an RTI, Millets, so it is legitimately obtained. Written by Accountant General, a DO letter to Mr. Y.L. Jami, IAS, Secretary to the Government. Millets, the first line. I am including a draft paragraph titled Suspected Misappropriation. See the travesty, Millets. The accuser, based on which everything has been done, that's the CAG, office of the CAG. The Accountant General, who is a very senior functionary, is writing to the state government that I am including a draft of suspected misappropriation. Millet, they are also not alleging that any misappropriation has taken place. They want some clarification. They say that may be possible. So there is no. So, my lord, respectful submission is, there is no actus reus. Milord, without actus reus, no crime can be committed or no crime happens. They are verifying. It's a process of verification, my lord. That is most important. And then, my lords, I will request my lords to kindly come over to page 8 of my affidavit, my lords. No actus reus, my lords, so nothing will happen. Page 8, my lords. This is the reply by Mr. Jami, who is the secretary to the
Page 8 of
8 minutes.
This same affidavit.
Same affidavit, Milord. Page 8, annexure 810, 8 minutes. Millards have got it?
Yes.
Grateful minutes. Millard, kindly, this is the reply of the DO letter of the Accountant General by the state government. Millard, subject is para relating to misappropriation of NLRMP fund, so and so. Millards, I am to forward herewith letter number so and so, along with its enclosure on the subject cited above, and to a state. My lord, state government is saying that the purported misappropriation of NLRMP fund have been conceived due to communication gap between the directorate and the district offices of the department. On cross verification of the available documents, it is understood that transactions have been carried out with the district offices during the predecessors of the officers presently posted, and thus irregularities in fund appropriation have not been established. You are therefore requested to kindly drop the matter in accordance with the reply of the director, LRNS. My lord, the state government is categorically stating that no misappropriation has taken place. There was a communication gap because the funds were utilized actually among the predecessors, and the reply has been given by the present one that there is no expenditure during their term. So this has now been reconciled by the state government. So please close it. And now, my lord, what is the date? That is the most crucial, my lords. If my lord can say at the bottom, my lords, 13th of June 2014, my lords. And the, my lords, the office note of Vigilance Police Station is 20th April 2015. This letter or official communication between the state of Nagaland and the office of the CAG was very much in existence. Why they ignored it? If they were not aware, they should have found it out. They should have checked from the government first that whether government is of the view that any embezzlement has taken place. My house is burgled. Everything is stolen. I am writing that no, my house has not been burgled. Nothing has been stolen. And my neighbors are, dying with anxiety that my house has been burgled. What is this? That is first, millets. Second, millets, this Vigilance Police Station is part of a state, not even a state. It's an organ of a state. Can it go against the state? Can it say that the state government is wrong? Offense has taken place. What is this? Ultimately, prosecutor is a state, millets. Here, victim is also a state. State is the final prosecutor. So state is clearly saying no offense has taken place, please close the matter, and matter was closed. No draft para was raised by the officer of the CAG, no such report was sent to the state legislature. Everything, but Vigilance Police Station has registered a case subsequently. Obviously, millets, I don't want to say, but one can understand that what was the purpose. Unfortunately, millets,
all this communication was before 21/4.
Before 20th April, millets, before that office note by which investigation was commenced. So this decision of the government was already taken and was very much on the file of the government. Maybe theoretically it is possible that Vigilance Police Station was not aware. Then they should have found it out first. They should have asked the state government, assuming they got some information, some inputs. First of all, they should have asked the concerned department, concerned secretary, that is, we have come to believe that some embezzlement is alleged. What are the facts? They didn't bother. They straight away started harassing these poor people, these officials. So here itself, millets, on the merits, assuming that there was an FIR, for the sake of argument, Millets, on this, the whole case collapses. No offense has taken place. The alleged victim, which is the state government, the final prosecutor, which is the state of Nagaland, is very categorically saying that this is a miscommunication. No such embezzlement has taken place. The work has actually happened. There was some communication gap between various layers of authorities. So please close the proceedings. And this is not being considered neither by the Vigilance Police Station Mills nor by the learned Lokayukt, unfortunately. Till date, taking up investigation in 2018 until 2025, learned Lokayukt has not asked the state government even once, which is a travesty of justice, that has any embezzlement taken place? If so, what the state government has done, what the state government is proposing to do. Everybody is going everywhere, but not asking the owner of the house, whose house is alleged to have been burgled, whose property has been alleged to have been stolen, that has any burglary taken place in your house? Has any property been stolen from you? No. So, Millard, where is the case for which I have been harassed since 2015, Millard, till now for 11 years? And I am suffering the stigma of harassment, humiliation, insult, threat of arrest, everything, Millard. This court has to protect me from getting arrested. So, Millard, that is the next part. Now, Millard,
Then,
I will request my lords to kindly consider my affidavit in reply. In fact, before that, my lord, I will request my lords to come to the reply of the state government. They have filed a written reply, my lords, very short reply, only few pages, but they have filed. My lords have it?
affidavit in opposition of
Yeah, affidavit in opposition to the state government.
respondent one.
Yeah, respondent number, state government, my lords. So, my lords, I will request my lords to come to page 2, para 4. With regard to the statement made in paragraph so-and-so and so-and-so of the writ petition, the deponent begs to state that the Honorable Up Lokayukt in case number so-and-so of 2015 has disposed the said proceedings by an order dated 20th of March 2025, inter alia stating that the Nagaland Lokayukt has conducted investigation based on findings during preliminary inquiry. Well, it's, as my lords rightly said, and to which I bow down with all respect and humility, Nagaland Lokayukt can conduct only an inquiry. It cannot conduct an investigation. The powers of the Lokayukt are defined in the Lokayukt Act. It has power to hold inquiry millets, but it doesn't have power to investigate a case. That is the prerogative of the police or learned magistrate. That's why police stations are attached. Now, millets, they can, to be fair, millets, they can conduct investigation only in one case, when there is a complaint directly to the Lokayukt. In this case, milord, there is no complaint or complainant. Pending proceedings by the enabling authority of subsection 3 of section 36 of the Nagaland Lokayukt Act 2017 millets. Pending proceedings has been taken over by the Lokayukt, that's all. So the first thing before conducting any investigation, the Lokayukt should have seen whether there is any complainant. They have not cared. So millard, on this ground also, this proceeding is bad. It cannot be sustained in the eyes of law. They have gone beyond their jurisdiction. Now, millets, why I am seeking intervention, that is very crucial. On the findings during preliminary inquiry, the apparent corruption of the then officials involved in implementing the project and its findings are shown in the abstract. Millard, apparent corruption. The Lokayukt is still calling me corrupt without following the due process of law, without complying with the requirement of law. That's why, millets, I cannot sit over it. I have to take it to the logical end, lawful end, millard. That's why I'm praying for my Lord's intervention. So, millets, if the last para, millets, on this page itself, page 3, it is pertinent to state herein that petitioner filed an application under 227 seeking the intervention of the Honorable Court for setting aside and quashing of the entire proceedings, which was originally registered in the Vigilance Police Station, Kohima, so-and-so, dated 20th 4, 2015. Now, millets, it is very clear that they are treating that office note as FIR, which can't be. That's why the state is replying, originally registered.
But the disposal of the Lokayukta, it's not adverse for you.
It's adverse from millets. Kindly read the top
Why?
para millets.
Why?
Apparent corruption of Daden officials. I am one of the Daden officials.
No, but after that, see the operative portion. This case is disposed of with a recommendation
Yes,
that
millets.
the government puts in place a proper check system.
Yes,
So
millets.
that's all.
Millet,
That
check,
the
proper
government should-
place a check in for future. What happens to this? Crime never gets barred, millets. It is either to be quashed or it is taken to the logical end. Tomorrow, that's what I'm saying, millet. Some PIL is filed. That crime cannot be hushed up. Just because criminal or the offender has become old or has retired from government service, crime cannot be closed. Crime never gets barred. So, millets, immediately another case can be registered against me. And again, same process. Why should I suffer? I have already suffered for 12 years being an innocent person. Now they want me again to suffer because Nagaland Lokayukta is unable to act lawfully.
Okay, please
So-
read, it is pertinent.
Yeah, so millet, last para I was reading, and with effect from 21/12/2018, was to transfer to the file of learned Lokayuk by virtue of the enabling authority of 36(3), and is now pending on the file of learned Lokayuk. At that time it was pending, millet, so reply is prior to order of the law. However, the learned Up Lokayuk by an order dated, my lord, kindly see, it's pending on the file of Up Lokayuk. So their state is not treating it to be closed. They are still considering. Now they are saying, however, learned Up Lokayuk by an order dated 20th March 2025 had disposed of the case number vigilance so and so. Deputy DIG has forwarded the same to the Chief Secretary and the matter is under process for state government to take a decision. So, my lord, the state is treating the complaint to be pending, case to be pending, but some report has come, which is basically an administrative measure to constitute a committee for monitoring in future, which they have accepted and constituted a committee. So, millets, as far as state is concerned, is very clear, and it is correctly so. State, this step is correct, that proceeding cannot be considered to be closed. Because Lokayukt has no power to close. That is the power of the learned magistrate or the superior courts. So a state is here for one's right. I am supporting the state this stand that this proceeding is still pending, but in the meantime a report has come which we are considering, which they have considered. So millet, that is that. Now millets, I will read next paras. That with regard to the statement made in paragraph 5, 6, 11 till 18 are in the nature of submissions. However, the deponent reiterate to the statement made in the preceding paragraph that instant matter has become infructuous. This is legally untenable, millets. Crime never becomes infructuous. For the fact that learned Up Lokayukt had disposed of by an order dated 20th March 2025, stating that this case is disposed with the recommendation that the government put in place a proper check control system, if not already in place, when such projects are implemented by any department of state government, to which state government is yet to take a decision on the order passed with learned Lokayuk, Nagaland, Kohima. So, millets, this para, as I respectfully submitted and I reiterate, closing a criminal case, rightly or wrongly initiated, is the prerogative of only a learned magistrate, Ilaka magistrate, not of the Lokayuk, not of the state government. Once a case is registered, whether it is right or wrong, a closure report, FR, has to be given to the learned magistrate. Because learned magistrate has jurisdiction to ignore the closure report, FR under section 169 CRPC, and take cognizance and proceed further. If my lords can just recall Arushi Talwar murder case, the CBI has filed a FR under 169 CRPC, closure report. The session judge ignored it, took the cognizance of the offense, framed the charge, and even convicted, which of course was reversed by the High Court, matter is now the Supreme Court. So, millets, here the submission of the state government that it has become infructuous is legally not sustainable. It is still pending, and it is pending against me. So, millets, I am entitled to invoke my lord's jurisdiction. Now, millets, I will request my lords to kindly come to my reply to this, where I have framed the issues one by one, and that will sum up my submissions, millets. It's a very small, millets, few pages only, submitted on 10th of November 2025. 10th of November, that is At the bottom, I have asked my associate to write it on the left side.
Yes, yes.
It should be always here,
11.
because it is very difficult for the court and even me to find out. Put it always here.
Reply of the petitioner.
Yes, my lord. So I will request my lord to kindly come to para 5 on page 3 of my reply. Page 3 minutes. I have summed up. The respondents have admitted all the grounds of fact and law as have been raised by the petitioner before this honorable court, and more particularly the following specific grounds of law, also a fact. So, minutes, my first submission is, no information about commission of any cognizable offence was received by any police station or by officer in charge of a police station as being mandatory under section 154 of CRPC 1973. Minutes, there are judgments. I have filed a compilation of judgments by Honorable Karnataka High Court. This is for us. Okay. In this case, Millers, the first judgment is a division bench of this honorable court, where it has been deliberated where any report, before it is accepted by the legislature of CAG, can be called information. Answer is no. So, Miller, I am relying on two judgments, one of the division bench of this honorable court, which binds us, being a larger bench, and second is the Honorable Karnataka High Court in the case B.S. Yediyurappa versus State of Karnataka and others. Same thing, Miller. The second is specifically on this issue where the report of CAG was treated as information and FIR was registered, everything has been set aside and quashed. Same identical millets. So these two I am relying, millets, and therefore my respectful submission is, millets, there is no information. That's why, millets, Accountant General has written in his letter, draft paragraph on suspected misappropriation. It is tentative, exploratory. So, millet, my first ground is, which I have summarized for my Lord's consideration, that there was never any information under section 154. Information means, millet, offense must have taken place already. Actus reus is over. Only thing to be seen is mens rea. So, millets, that is the first part. So, 154 cannot be triggered. Now, next, millets. No information about commission of any cognizable offense was received by any police officer or by officer in charge of a police station as being mandatory under section 157. Because, millets, an FIR can be registered under section 157 also based on source information of a police officer, where police officer becomes the complainant. So that also is not there, millets. Then third, millets, no FIR is registered. My lords have already considered, so I am skipping it. Then, millet, fourth, no investigation was triggered under section 156(1) of CRPC as is mandatory. And, millets, I have explained even 203 is not applicable. So, millets, because there is no information, no FIR, so 156(1) cannot be operated. Next, millets, fifth, the report of the CAG of India was tentative and merely an opinion of the auditors that has not yet become information. Millets, that's why the word used is draft paragraph and suspected misappropriation. So it is not information, it is tentative opinion. So this is important, millets. Then, millets, the report of CAG of India alleging the commission of the alleged irregularities by the petitioner was rejected by the government of Nagaland, and the Secretary of Government of Nagaland had duly informed the office of the CAG of India that report about the commission of the alleged irregularities by the petitioner was factually incorrect, as was not accepted by the government of Nagaland, as no such irregularities were committed. This is the letter of the Secretary dated 3rd of June 2014. That my lords have just seen. Then, millets, there was a lawfully instituted investigation. There never was a lawfully investigation under the law. An impugned vigilance police case so and so, as initiated by Vigilance Police Station Kohima, was ex facie ab initio res ipsa loquitur unlawful. Then, millets, no pendency as advised by, as envisaged by section 36(3) of the Nagaland Lokayukta Act so and so, with effect from 21st December 2023, got transferred to the file of learned Lokayukt Nagaland as there was any such pendency pending on the file. Now, millets, these are summarized. One ground that is already taken in my petition, one more ground, millets, that's all, millets. The millets, there is no provision of, there was, in fact, millets, I'm sorry, I stand corrected. There was no provision of any preliminary inquiry or any inquiry by the police under the CRPC. Now it is there. It has been brought in BNSS under section 175(3). Police can make inquiry. So, Millets, in the Lalita Kumari Constitution Bench of the Supreme Court, they provided under Article 142 of the Constitution that in certain specified cases, police will be making an preliminary inquiry because complaints can be motivated. So, Millets, in my petition, I have reproduced those directions of the Honorable Apex Court. If my lords can come to my petition, para 15, page 11 minutes. My petition minutes, I'm sorry. Page 15 minutes, page 11, para 15 minutes. Well, it's got it? My lords. I'm reading it. As per Manual 3 of the State Vigilance Commission, Nagaland, the procedure to be followed by the Vigilance Commission of Nagaland under which the Vigilance Police Station Kohima functioned was to first register a preliminary inquiry to verify the facts, and thereafter, with prior approval of the State Vigilance Commissioner, here, Millet, approval is also to be taken from the Vigilance Commissioner and not the IG. The preliminary inquiry was to be converted into a regular case and was to be registered by the Vigilance Police Station to undertake investigation under CRPC so-and-so, but no such procedure was followed by the State Vigilance Commission and Vigilance Police Station Kohima, with straight away registering the regular case and undertaking investigation in the matter, which was entirely illegal. And petitioner respectfully relies upon the law as laid down by the 5-judge Constitution Bench, in the case of Lalita Kumari was State of UP. The material paras are this. Para 110 starts, Millets, which says that there will be a mandatory P and conclusion directions, para 11 minutes. If my lord can come on the page 13, the bottom of the page, Millets, the category of cases in which the PI may be made are as under: matrimonial disputes, commercial offences, medical negligence, corruption cases, Millets. So, Millets, it is a case of corruption. The public officers are alleged to have embezzled the government money. So, preliminary inquiry is mandatory. No PEs was conducted, which was otherwise also prescribed by the State Vigilance Manual. Not only that, Millets. In fact, had that been complied, probably my lords could have recused. The State Vigilance Commissioner's approval is necessary, and which has not only not been taken, file has not even been put up to him or her. No procedure has been followed. They straight away registered a case without bothering to check up what is the state government's stand and started acting against the poor victims. So, Millets, all these things taken together, Millets, at every step, there is illegality, no procedure is followed, no law is followed. No, that is some of it already. Then, Millard, one more thing, just last, my associate has rightly pointed out. Just last argument, Millard, then I will finish.
Yes.
Millard, the report of the CAG or alleged embezzlement is pertaining to financial year 2013-14. Millets, my lords are aware, we follow 1st April to 31st March financial year, the SAC era. So, Millet, financial year 2013-14 means 1st April 2013 to 31st March 2014. Millets, I became director, that Mr. Keetan became director on 3rd of June 2014.
3rd of June
2014, June, 3rd June, Millets. And then continued up to 31st December 2023. So, Millet, the offense which has alleged to have been committed is committed prior to my becoming director. I'm not the director. So I can't commit the offense of a director when I'm not the director. On this ground itself, ignoring all other my grounds, simple thing. Financial year 13-14, on which there is no dispute, I become director only in 14-15.
3rd June 2014.
2014, Millet. I have enclosed my joining order also. And that is not, state is not disputing, so that can be accepted by the Honorable Court. So, Millet, even if I don't have the benefit of my various other legal grounds, Millet, when the offense is committed on or before 31st March 2014. I become director on 3rd of June 2014. That is the next financial year 14-15. So, Millets, I can't commit offense when I'm not there. I'm not at bond as director. So, my lord, that is my respectful submission, my lord. He's an old man, unnecessarily suffering the stigma, humiliation. His pension is not finalized. He's getting provisional pension. His other benefits are held up. And, my lord, one last, my lord, I'm sorry. And because that is already taken in the ground, my lord, in the Ashu Surendranath versus CBI, that judgment is part of my compilation, my lords.
Which one? Serial number?
Yeah. Serial number 5 minutes. That Ashu Surendranath,
Yes.
Tiwari versus Deputy Superintendent of Police, EOW, CBI and another. Here Supreme Court has said that if no departmental action is initiated on alleged irregularities by the government, no criminal case will lie. Because, my lord, preponderance of probability is much lighter ground. If no case is made out, and even on preponderance of probability, certainly no case can be made out on the grounds of rule of evidence. So this is a very important judgment, my lord. I have taken the grounds. And second, one more judgment more, my lords. That's serial number 4, which is repeated as serial number 7 also. But
Serial number 5, the case is on the.
if no departmental inquiry, then no criminal
conducted,
case
so
on the
till-
same facts.
Till today, no department.
Till today, no department. My statement can be recorded, and the state is not contesting this. They have not given me any departmental charge sheet or anything. Obviously, they can't give me that. As far as state is concerned, they are saying no embezzlement. So how can they prosecute me for embezzlement when they are saying no embezzlement? And 4, my lord, 4 is important. The state of Punjab versus Davinder Pal Singh Bhullar and others. In this, one of the findings of the Supreme Court was that if initial action is illegal, the foundational action is illegal, all subsequent actions will also become illegal. So, my lord, if the first action of initiating criminal investigation itself is illegal, everything done subsequently is illegal. That is, my lord, the order of Lokayukt, the proceeding of Lokayukt also is illegal. So that's why I have relied on to this judgment, my lords. So that is all, my lords. I pray for the consideration, my lords. I bow down to Honorable Court. My brother can assist, my lords.
Yes. Actually, what is happening in the Lokayukta, I don't understand. What's happening to all those criminal cases which came from vigilance? So they're all just kept like that? Because
Actually,
they have
there
to
is a-
come
there
to
is
a
a-
closure. And the Lokayukta cannot close it because it's a
Yes.
criminal case.
Yes. There is some institutional, my lords, deficiency.
So there may not only besides this
General,
case,
general, my lord, general,
in
academic
general, there may
purpose.
be other
In fact,
criminal.
my lords can take it up as suo motu writ petition. I will assist pro bono. And my lords can consider this and pass suitable orders for the state government to follow. That will be a
There may
separate.
be other criminal cases also, isn't it? Which have been taken over by the Lokayukta. And they cannot proceed, they cannot close it also.
But that's why they are saying-
There may be an option of maybe transferring all those to a police station.
Lordship.
My lords can issue some directions separately to the state government. This court is competent.
Lordship, as far as this incident matter is
Anyway,
concerned,
yes.
Lordship,
This, my lords, deserves to be quashed.
Yes.
Lordship, I'm for respondent number 1. I have a limited submission, Lordship. Lordship, I have stated, I have read out my
Actually, your role is
Lordship.
limited because,
Lordship, para 4 and 5, Lordship. Now, Lordship, if we go to the prayer of the instant petitioner, Lordship may kindly come to prayer portion of the petition, which is at page 24. The relevant will be 25,
the prayer portion.
prayer portion. Lordship, here the prayer they have invoked, they have approached this honorable court under 227, Lordship. Invoking the, Lordship, here the
528 is also there. 528 BNSS.
Lordship. Lordship, here to set and question aside the entire investigation, Lordship. And Lordship, that has already been answered. Lordship, rightly or wrong, the Lokayukt has disposed of the matter on 2003.
But that is the question. How can the Lokayukta close a criminal case?
Lordship. And the government is yet to take a decision on that.
Even government cannot close, my lord. The state has no power to close the proceeding.
The
They have
government
to go
also
back to the
cannot
magistrate.
close.
That's why 227 has been invoked.
Only the court can close it.
Only the Ilaka magistrate or a superior court can order closure of a criminal proceeding. Jurisdiction is very clear. The state is the party. It's either a victim or a complainant or a respondent. So a complainant, a party to the list cannot close the list, my lords. That has to be a neutral, independent institution, which is the court. And my lords, state has no answer. My brother is not objecting anything on the facts. So why the harassment of an innocent citizen be continued or allowed to continue, my lords? Just because some confusion created by Lokayukt.
Okay.
My lords. Everybody.
My lord, while we are waiting for the steno, I have second consent to this honorable court.
Oh, that unlisted
Yes,
motion?
my lord. It's a transit of disciplinary bill.
Already
Filing-
filed.
Yes, filing has already been done. Number
Let's
has
see,
al-
let's see.
Also been given. You are next.
Learned counsel for the petitioner, Mr. S. Srivastava.
SK, my lords.
SK. Yes,
With assisted by Mr. Angel Lotham.
assisted by Mr. Such and such. Also heard Mr. V. Zimumi for the respondent number 1. Matters disposed of. Just say matters disposed of. I'll dispose of in the chamber.
No, my lords.
For admission, item number 3.
Once it closed.
May I please see Lordship? Lordship, here I'm praying for the release of my vehicle, Lordship, which was seized on 14/12/2023, Lordship. Lordship, here,
Who's appearing for this case?
this is a DRI case, Lordship. DRI.
Okay, okay.
Lordship,
So what about notice?
Yes, Lordship, it's completed, Lordship. Lordship, if you may kindly see the order dated 27/1/26.
27-1.
Yes, Lordship.
Okay, what about CGC?
CGC. This morning, there was a vote paper, but no one appeared, Lordship. Sir Yangarwati. Lordship, here, my vehicle is very old, Lordship. It's 2012 registration, Lordship. And moreover, it's been under the custody for more than 2 years, Lordship. So if your Lordship may be gracious enough to dispose of without...
At least let the CGC be there. Listed again on Monday, okay? You tell him.
Okay, Lordship.
Learned counsel for the petitioner, Mr.
Mr. Kachishi, Lordship.
Kachishi is present. Stop. None appears for the respondents when the matter is called. Stop. List the matter again on 23/2/2026. Stop. The learned counsel for the petitioner shall inform the CGC just inform the CGC regarding the listing of the case. Okay.
Obliged, Lordship.
For admission, item number 4.
Yeah, please, Your Lordship. My Lord, this IA is for condemnation of 879 days. And the appeal is filed against the judgment passed by the Special Judge Fast Track Court, Dimapur. And ground for condemnation is in page 11,
Conviction for how many years?
7 years.
7 years. Yes, what are your grounds? Let's see.
Page 11, para 13.
Page 11. Yes.
Yes, if I may be allowed to read. That the judgment was passed on 10/11/2022. However, the present case was endorsed to the present council only on 11/6/2025. Therefore, the delay period before the endorsement letter dated 11/6/2025 was caused while passing on the files to appoint the legal aid counsel for filing the
Oh,
present.
this is a legal aid case.
Lordship.
Okay, okay. Yes, Mr. Zimami will condone because this is statutory appeal, and it was endorsed. It's taken up by the legal aid.
Lordship.
Yes.
However, Lordship, I'm yet to receive instruction with regard to the objection to the condemnation. And I'm still waiting for the instruction.
Lordship, in such cases where the personal liberty,
I think we will just condone because objection also. What objection will that take? Due to ignorance, he has been languishing in behind the bars, and only after the legal aid took over, they have filed it. Okay, let's go to the IA. Okay, learned counsel for the petitioner, Miss such and such. Learned, you are appearing as legal aid counsel.
I'm appearing on behalf of my senior Joshua Shiki.
Okay, appearing on behalf of Joshua Sheki for the appellant who has been engaged as a legal aid counsel to represent the appellant herein. Stop. This application has been filed under Section 5 of the Limitation Act 1963, praying for condonation of delay of 879 days in filing the connected criminal appeal against the judgment dated 10/1/2022, passed by the Special Judge, Fast Track Special Court, POCSO, Dimapur, Nagaland, sentencing the appellant to undergo rigorous imprisonment for a period of 7 years, with fine of rupees 20,000 under Section 376 IPC, read with Section 7 of the POCSO Act. Stop. Para. Learned Public Prosecutor V. Jimomi appears for the state respondent, and Mr. Nomos appears for respondent 2, or the respondent 2, as legal aid or amicus. Okay, for as amicus for respondent number 2. Stop. Para. The reasons for the delay has been set out at paragraph 11 of the application.
Paragraph 13.
Paragraph 13 of the application. Stop. The court has perused the same and find that the sufficient cause has been shown for the delay. And accordingly, the delay of 879 is it? 879 days is condoned and the application is allowed. You come to the main case, criminal appeal. The present criminal appeal has been filed under Section 374 of the CRPC, read with, what is the corresponding section? Corresponding to section such and such, just leave a blank, we'll fill it, such and such of the BNSS. Stop. The appeal has been filed assailing the impugned judgment dated 10/1/2022, passed in GR number 253 of 2014, passed by the learned special judge, Fast Track Special Court, POCSO, Dimapur, sentencing the appellant to rigorous imprisonment for 7 years with fine of rupees 20,000 under Section 376 IPC, read with Section 7 of the POCSO Act, and with a default clause to undergo another 1 year of imprisonment. Stop. The appeal is admitted for hearing. Stop. The respondents are represented by the public prosecutor, Mr. V. Jamomi, and Mr. Nomosa for the respondent number 2. Stop. Hence, no formal notice is called for. Stop. para. The registry shall call for the records, trial court, scanned copy of the trial court records from the special court, from the fast track special court, POCSO, Dimapur, Nagaland. Stop list after.
Lordship, if the paper book may also be.
No, we have to first call for the records.
Lordship.
Call for the records, then list after 4 weeks.
Obligement.
For admission, item number 6.
May I please, Your Lordship? This is one of those rare cases where the main respondent is not contesting the case, in spite of the fact that the service upon them has been affected. Respondent number 4 to 6, they are the main respondent, Your
4 to
Lordship.
6.
And state respondent, Your Lordship, I have met them by way of abundant caution. Otherwise, even on the last occasion, state is represented by M. Longkumar. He has also placed before Your Lordship this court the instruction which he has received from the state government that the state has nothing to say, and rightly so. Because Your Lordship, what I am challenging is the action of the municipal council, Dimapur Municipal Council.
Okay.
Now,
And they are not appearing.
yes, I have been allotted a parking area at New Market in Dimapur, Your Lordship. Now, on monthly rental
You have taken
basis,
steps by Dusty.
I have taken step by Dusty.
And affidavit also filed.
Kindly come to the order regarding the steps.
We have to make sure, first that notice is complete.
The order dated 9/9/2025. 9/9/2025, Lordship has got it.
Yes.
The second paragraph. Accordingly, notice on respondent number 4 to 6 is deemed to be duly served.
Okay.
And regarding the stand taken by the state respondent here, may I take Your Lordship to order dated 14/11/2025.
14/11.
14/11/2025. Lordship has got it.
Yes.
Second para. Mr. M. Longkumar, Learner State Council, he is representing 1 to 3, Your Lordship, submits that as per the instruction received by him, the matter solely pertains to the dispute between the petitioner and respondent number 4 to 6. He submitted respondent number 4 is the CO, whatever. Respondent number 4 who should respond to the matter. In other words, state has got nothing to say, Your Lordship. Now, of course, today M. Longkumar is not before this court, Your Lordship, but going by what has been recorded in the order, even if his presence is there, Your Lordship,
nothing to say.
he has got nothing to say, Your Lordship. And just coming to the facts straight, Your Lordship, just take Your Lordship to a very short matter, three annexures only, page 17, annexure 1. Lordship has got it?
Yes.
May I read out? This is the allotment order dated 25th November 2022. As per the direction of the authority, Srimati Somet Chang, she is the petitioner, Your Lordship. Some resident of such and such, mobile such and such, is hereby allotted the parking area situated on the ground floor and first floor New Market flyover connecting GS Road and Nyamulota Road, New Market, Dimapur, as allottees under the following terms and conditions. So 1, 2, 3, and 8. I may be allowed to read.
1, 2, 3, and 8.
Yes. That the allottee shall have to deposit a sum of rupees 1 lakh only as allotment fee, non-refundable. That the monthly rent for the parking area, ground floor and first floor shall be in the tune of rupees 30,000 only per month. 3. That if the allottee fails to deposit his or her rent to the DMC, Dimapur Municipal Council, consecutively for 3 months, then it will lead to the cancellation of allotment with or without notice. 8. That this allotment is not transferable and it is purely temporary basis, it can be cancelled or evicted as and when the said area is required by the DMC for any other purpose or for development work last date is relevant rather than the purpose for which allotment has been made. In other words, it cannot be allotted to others, but
for any other purpose.
but if it is required by the DMC for any other purpose or for development work, but not to rent it out again to another person, Your Lordship. Now, as per the terms and condition of this allotment order, page 18, this is ₹1 lakh which I have deposited. The security is non-refundable. And page 3, Your Worship, from 19, at those the receipt, the monthly rent which I've been paid. And page 20, annexure 4, this is the last which I paid on 7/8/2025 for the month of August. Your Worship. Now the impugn order is at page 21. This is dated 12 August 2025. In the interest of public convenience and as per the power conferred under the Nagaland Municipality, it is hereby ordered that the allotment of parking space made in favor of such and such, located on ground floor and first floor of New Market flyover connecting such and such, stands cancelled with immediate effect. The cancellation has been necessitated due to administrative reason, Lordship may kindly mark, and in view of requirement to ensure proper regulation and public utility of municipal assets. Sri Somechang is directed to vacate the said premises on or before 31st March 2025 without fail. Before that, I approached this Honorable Court, so Lordship, there's an interim order. I am still in position. Okay. Now, the next page, 6. Parking permit. This is dated 19 August 2025 at the bottom. I have also given type copy. In excess of the power conferred under the provision of the Nagaland Municipal Act 2023 and in the interest of public convenience, permission is hereby granted to Srimati such and such and such and such. They are respond number 5 and 6.
Okay. They are also not approved.
For the operation and management of the parking space located at ground floor, terms and conditions, security fee is there. 2, that is monthly. So, this is in clear violation of the terms and conditions.
And your allotment order was parking area, same.
Yes.
Parking space.
Same.
Parking area, okay.
And Lordship may kindly see my annexure 1, page 17, the terms and condition 8. They can cancel it, they can evict me, but not for the purpose for which.
Not for the same purpose.
Yes. And then this impugn order has been issued without giving me any opportunity, without giving me any show cause, and therefore, Your Lordship. Now, I have approached this court before 31st, the deadline which was given to me. So may I take Your Lordship to the first order passed by this court on 26/8/2025. 26/8/2025.
Yes.
Para 8. Lordship may come to para 8. The petitioner herein was issued an allotment order that is whereby she was allotted a parking area situated on the ground floor and first floor New Market flyover connecting GS Road and Yamulota Road, New Market, Dimapur under certain terms and conditions. It is the case of the petitioner that petitioner was all along abiding by the terms and conditions contained in the allotment order. However, to utter shock and surprise of the petitioner, a cancellation order was issued on 12/8/2025, whereby the petitioner was informed by the respondent number 4 that the allotment order has been cancelled for administrative reason. It is the case of the petitioner that the said cancellation order was not preceded by any notice, and as such, it is in violation of the principle of natural justice, which is a facet of Article 21 of the Constitution of India. The learned counsel of the petitioner submitted that the reason for which the cancellation order was passed appears to be to accommodate respondent number 5 and 6, not for administrative reason, which is on the face of it shows that the action on the part of respondent number 4 not only suffers from malice in law, but also in complete abuse of the powers conferred upon the state authority. He further submitted that the said petition has been directed to vacate by 31/8/2025 and therefore submitted that there is an urgent need for passing a certain interim direction, failing which the very filing of the instant petition would become infructuous. The court has duly taken note of the materials on record as well as the impugned order dated such and such as well as the consequential order by which the respondent number 5 and 6 have been allotted the parking area. Taking into account the submission so made to the effect that the said allotment of the petitioner was cancelled without following the due procedure and more particularly in violation of the principle of natural justice as submitted by the learned counsel for the petitioner. It is the opinion of this court that the petitioner is entitled to a certain interim direction. Accordingly, this court directed till the next date status quo be maintained. So accordingly, Your Worship, I am still running the parking area, Your Worship. Now, my whole submission is that the cancellation order has been issued without giving me any opportunity, and not only that, that was also in clear violation of the terms and conditions of the allotment order, in particular terms and condition number 8, Your Worship. Now, when it matters, relating to violation of natural justice, there are so many authorities, but Your Worship, I'll just place one, this last constitutional bench, latest one, 2025 for SCC, 641, one just a case law on violation of principle of justice.
Okay,
2025.
Just give me one then.
(2025) Volume 4, SCC 641. And the fact that the respondent number 4, in particular, they are not contesting the case, by not contesting, they are admitting that no notice has been given to me before cancellation of the allotment order.
That's why maybe they don't want to contest.
Yes. So para 79 and 80, this by constitutional bench, Your Worship.
Para 79.
Say para 79 and 80, but I will skip para 79, para 80.
Yes.
Article 14 is an important facet of administrative, judicial, and quasi-judicial decision-making in India and demands fair play in action. The object of observing the principle of natural justice is to ensure that every person whose rights are going to be affected by the proposed action gets a fair hearing. By the cancellation or impugned cancellation order, Your Worship, my right has been affected. Before that, Your Worship, it is incumbent on the part of the respondent, the authority, the company, at least to give me an opportunity, Your Worship. So since the impugned order has been issued without giving me any opportunity, in total violation of the principle of natural justice, and in addition to that, in clear violation of the terms and condition, in particular terms and condition number 8 of the allotment order, Your Worship, the impugned cancellation order, Your Worship, is not legally sustainable and liable to be quashed and set aside. That's all.
Heard learned counsel for the petitioner, Mr. T.B. Jamal. Also heard Mr. V. Jimomi for the respondent number 1. No, respondent number 1, 2, and 3, I think.
1, 2, and 3.
1, 2, and 3. Stop. None appears for the respondents number 4, 5, and 6. Stop. By order dated 12/2/2026, no, sorry, not that. By order dated 9/9/2025, this court has already observed that the notice on respondent number 4 to 6 is duly served. Stop. Para. The present application under Article 226 of the Constitution of India has been filed by the petitioner, impugning the cancellation order number DMC/parking/2025-26:1299-301 dated 12/8/2025, issued by the Chief Executive Officer, Dimapur Municipal Council, Dimapur, Nagaland. Stop. The petitioner has also assailed the impugned parking permit number DMC/parking/2025-26:1363-364 dated 19/8/2025, issued by the Chief Executive Officer, Dimapur Municipal Council, Dimapur, Nagaland, by which the respondent number 5 and 6, isn't it?
Yes.
Respondent number 5 and 6 were allotted the parking permit at the ground floor and first floor of New Market, Dimapur. Stop. Para. The case of the petitioner is that by an order number DMC, your first order is at page DMC/DEF-11/2022 dated 25th November, no, is it 25th or 26th? 25th November 2022. No, 23rd November 2022. The petitioner had been allotted the parking area situated on the ground floor and first floor, New Market flyover, connecting GS Road and Niamo Lothar Road, New Market, Dimapur, as an allottee. Stop. The important points. The important condition has been stipulated at condition number 1, 2, 3, and 8, wherein it has been stipulated that the allottee shall deposit a sum of rupees 1 lakh as allotment fee, that the allottee shall pay a monthly rent of rupees 30,000, that if the allottee fails to deposit his/her rent to DMC consecutively for 3 months, then it would lead to the cancellation of the allotment with or without notice, and further that the allotment is not transferable and it can be cancelled/evicted as and when the said area is required by the DMC for any other purpose or for development works rather than the purpose for which allotment has been given. Stop. Para. The Learned Counsel for the petitioner submits that the petitioner has fulfilled all the terms and conditions as set out in the allotment order dated 23rd November 2022. Stop. The enclosures to the writ petition has shown that the petitioner has paid the initial deposit of rupees 1 lakh and has been paying the rent of rupees 30,000 every month without fail till 7/8/2025.
This is the last monthly rent paid for the month of July.
Okay, then after that you came to the court.
Yes, in August it was
After that,
cancelled.
August it was cancelled. Till 7/8/2025. And by impugn order dated 12 August 2025, the allotment given to the petitioner was cancelled by the Chief Executive Officer, DMC/Respondent 4. Stop. Para. It is in the cancellation order. It has been stated that the cancellation has been necessitated due to administrative reasons and in view of the requirement to ensure proper regulation and public utility of municipal assets. Stop. Para. Thereafter, the impugned allotment order
Page 22.
Allotment order dated 19th August 2025 was issued in favor of the respondent number 5 and 6 in the same place where the petitioner had been allotted and for the same purpose. i.e. parking space. Stop. The learned counsel for the petitioner submits that the petitioner was not given an opportunity of being heard before the cancellation order dated
23 11 2022 November.
2022 was passed. Stop. It is also submitted by the learned counsel that the terms and conditions of his allotment order dated 23/11/2022 clearly stated that the allotment can be cancelled only if the said area is required by the DMC for any other purpose or for developmental works other than the purpose for which allotment has been given. Stop. However, the impugned allotment order dated 19/8/2025 issued to the respondent number 5 and 6 clearly reveals that they have been issued the allotment for the same purpose, i.e. the parking permit. Stop.
And therefore, the impugned cancellation order of my allotment is not for administrative reason.
Yes, and therefore, the impugned cancellation order of the petitioner's permit was not for any administrative reason or for any developmental works, nor was it given for another purpose. Stop. Then what is the judgment?
So my submission is that the impugned
Therefore,
liable to
learned,
cost.
in view of the above submissions, the learned counsel for the petitioner submits that the impugned cancellation order is arbitrary and unreasonable and in violation of the
principle of
natural justice.
And is liable to be
And
interpreted.
prays that the impugned order may be quashed and set aside. Stop. The learned counsel for the petitioner has also further relied on the case of Central Organization for Railway Electrification versus such and such. I'll just give you that. reported in 2025 for SCC 641, wherein the Honorable Supreme Court has held that, then you just reproduce this para 80, okay? Para 80, I've marked the relevant portion. Stop. Para. Learned Government Advocate, Mr. V. Jimomi, has fairly submitted that the dispute in the present writ petition pertains to the petitioner and the respondent number 4 to 6, and therefore the respondents number 1 to 3 have nothing to submit. Have nothing to submit. Stop. This court has considered the submission of the learned counsel for the petitioner and has also perused the pleadings as well as the enclosures in the writ petition. Stop. A perusal of the allotment order dated 23/11/2022 shows that the petitioner had been allotted a parking area on the ground floor and first floor New Market flyover for parking purpose, isn't it? For parking purpose. And the terms and conditions therein stipulated that the allottee had to deposit a sum of rupees 1 lakh as allotment fee and thereafter to pay a monthly rent of 30,000. So one of the terms and conditions is that if the allottee failed to deposit his or her rent for 3 months, then it would lead to the cancellation of the allotment with or without notice. Stop. The most pertinent condition, is that the allotment is not transferable, and it could be cancelled only when the said area is required by the DMC for any other purpose or for development works rather than the purpose for which the allotment has been given. Stop. It is seen that the petitioner has duly deposited the amount of rupees 1 lakh before the DMC/R4. Stop. It has also been seen that the petitioner has been paying the monthly rent of rupees 30,000 regularly without fail. Stop. The court has also perused the impugned cancellation order dated 12/8/2025, wherein the respondent number 5 has stated that the said cancellation has been necessitated.
Lordship, to be respondent number 4, not 5.
Oh, sorry.
DMC.
Respondent number 4 has stated that the said cancellation has been necessitated due to administrative reasons and in view of the requirement to ensure proper regulation and public utility of municipal assets. Stop. It is also seen that before passing the cancellation order, impugned cancellation order dated 12/8/2025, the petitioner was not given an opportunity of being heard and no notice was issued to her. Stop. Para. On perusal of the impugned parking permit dated 19/8/2025 issued to the respondent number 5 and 6, it is seen that the respondent 5 and 6 have been allotted the same space which was allotted to the petitioner, and for the same purpose, i.e. parking purpose. Stop. It cannot be said that the said allotment, the said parking allotment of parking permit to the respondent number 5 and 6 was for administrative purpose, and it also cannot be said that it was required by the DMC for any other purpose or for developmental works. Stop. As it was held by the Honorable Supreme Court in the case of Central Organization for Railway Electrification, SUPRA, the non-observance of natural justice, the non-observance of the principles of natural justice is a prejudice to any person who has been denied justice. And the object of principles of natural justice is to ensure that every person whose rights are going to be affected by the proposed action gets a fair hearing. Stop. In the present case, this court has observed that the principles of natural justice have not been observed, and moreover, the respondent number 4 has violated the terms and conditions of the allotment order dated 23/11/2022, especially in respect of condition number 8. And therefore, the impugned orders cannot stand the test of law, and they are accordingly quashed and set aside. So, the petition is allowed and disposed of. Yes.
But
Unlisted motion, item number 16.
Lordship, the facts in a nutshell is that on 23rd of November 2025, a friend of mine, one Mr. Lanu, he asked me to assist a non-Laka, a lady by the name of Miss Rose, saying that since she is a non-local, she is facing difficulties to open a bank account here in Nagaland, in Dimapur. So you kindly open a bank account under her name. So I agreed. And then the next day, that is Monday, on 24th of November, I went to the bank, opened the bank account, deposited 1,000 rupees, which was given to me, of course, by Miss Rose. And then after that, the bank passbook, the SIM card, which was linked with the bank account. That is 8415055296. All this, as well as the ATM card, all this was handed over to that lady. And the account was opened at this Indian Overseas Bank in Dimapur. Now, on that day, I took a picture on 24th of that said Miss Rose.
which I have Annexure 2, Annexure P, page 15. Now I have also given the address of my friend who is staying in Dimapur, that said Mr. Lanu at paragraph 2. The last part of the paragraph.
Okay.
He has been staying there, their family has been staying there for a considerable period of time. Now this Miss Rose also, she is well conversant in Nagamis. That means she has also been staying in Nagaland for a considerable period of time. Now, surprisingly, on 19th of January this year, a notice was received from the Shivamoga police station at Karnataka, saying that my bank account, that Indian Overseas Bank account, as well as the SIM card, which is linked to that bank account, is being used to commit fraud, online frauds. The notice that I have received under section 35 subclause 3 of PNSS is annexed at Annexure T.
Annexure?
D for dog.
D.
Page 21, my lord. The type copy is at page 22.
Yes.
This is to inform you that I am the investigating officer of the above referred case. That means they have already registered a case, which is cyber crime, police station FIR number 133/2025 under sections 66D IT Act and 318 subclause 4 and 319 subclause 2 of the BNS. So basically, they are also stating that the Indian Overseas Bank account number so and so is being used to commit fraud. And then, my lord, I have been summoned to appear before the investigating officer today at Karnataka. Now, I have apprehension of arrest, which is why, my lord, I am praying for, it is not that I will not appear, I will appear. Perhaps today it will not be possible because I am under treatment. Which
whatever it is, you will have to go.
Yes, my lord. Now the treatment certificate. I am undergoing rehab treatment. Annexure F, page 25.
Annexure F.
This is to certify that Mr. So-and-so has been going through a recovery program at our Integrated Rehabilitation Center for Addicts run by the Youth Mission.
Okay.
So, my lord, at this stage, I pray that transit anticipatory bail may be kindly be granted to me as per the law laid down by the
But
Honorable.
you will have to go before the regular court there.
Yes, my lord, my lord.
File.
My lord.
Yes.
If 60 days transit anticipatory bail is kindly granted because
60 days.
Yes, my
30
lord.
days will do.
My lord,
30 days.
Anticipatory bail 4, 5, 6, and 7 passed by this honorable court last year. They have granted 45 days. I may be allowed to.
45 days.
Because, my lord, why I say so is if that Miss Rose is arrested, then I have a good chance of being discharged from the liability of this case if a fair investigation is being conducted.
But still, then you have to
Yes,
go
yes,
and appear
yes,
before
yes,
the
I'll
IO.
go,
So
yes.
I think okay, 45 days then.
If it can be kindly 60 days.
The present application under section 482 of the BNSS has been filed by the present petitioner, praying for grant of anticipatory transit bail to the applicant. Stop. Heard learned counsel for the petitioner, Mr. Cynthia. Stop. It is submitted that the applicant has received a notice under section 35 clause 3 BNSS dated 19/1/2026, issued by the investigating officer in where was that?
Page
In
21, ma'am.
cybercrime
Police
police
station,
station
Shivamoga.
FIR number in police station FIR number 133/2025 under section 66 clause D IT Act and 318 clause 4/319 clause 2 B after BNS pertaining to Shivamoga SHIVAMMOGGA Shivamoga Police Station Karnataka. Shivamoga Police Station Karnataka. So, it is submitted that the petitioner is undergoing rehabilitation treatment, and as per the medical certificate which is enclosed in the petition, medical certificate dated
17/2/2026, my lord.
17/2/2026 enclosed in the petition. The present petitioner is undergoing treatment and rehabilitation for substance use disorder and associated health concerns, and he requires residential care and clinical supervision and is unfit to resume regular duties or to attend official proceedings until completion of the treatment. So, the learned counsel for the petitioner submits that the petitioner is ready and willing to cooperate with the investigation. However, in view of the above submissions, it is prayed that he may be granted transit anticipatory bail in the interest of justice. So, the court has perused the pleadings and has considered the submission of petitioner. So, on considering the facts and circumstances, this court is inclined to grant transit anticipatory bail for a period of 50 days or 60 days to the applicant / petitioner in the event of arrest. The petitioner shall the applicant shall execute. No, for that I think you have to go to the legal court. Transit anticipatory bail for 60 days in order to enable the applicant to approach the jurisdictional court for seeking anticipatory bail in connection with the above mentioned case. The present transit bail, anticipatory bail granted to the applicant shall expire immediately on lapse of 60 days unless a regular anticipatory bail is granted to the applicant by the concerned jurisdictional court. So, no, but again, during the period of anticipatory bail, you will have to appear before the IO, isn't it?
Yes, my lord, my lord, my lord.
The applicant shall also appear before the IO, and in the event of arrest, the arresting authority shall release the applicant on executing a bail bond of rupees 30,000.
My lord.
We'll have to close the petition.
Yes.
Yes, petition is closed. With the above direction, the petition is closed.
Deeply obliged, my lord.